So thanks everyone for joining us for today's event. This is a part of a mini series of webinars which highlight the questions most frequently asked on our helpline from the top 5 most common topics. And these are discipline, dismissal and grievances, contracts, redundancy, layoffs and TP, wages and minimum wage, and diversity and discrimination. And today we're going to focus on your wages questions. Before we get started, I'm going to explain a little bit about who Acas are and what it is that we do. So we provide employees and employers with free impartial advice on workplace rights, rules and good practice. We also offer training for your workplace and we have courses available to book now, and we're going to send a link for that in the chat. We help to resolve disputes, and our online advice is updated regularly, where you can find the latest information about good practice for employers and employees. Our website has a number of free template letters, forms and policies for employers, HR managers and employees, which are free to download and use. So in today's webinar, we're going to be looking at the commonly asked questions on this topic. But first, we thought it was a good idea to define some terms. So the national minimum wage and national living wage are the minimum amount an employer must pay on average for the hours worked. The national minimum wage applies if you're aged under 21 or an apprentice under 19 or aged 19 and over and in the first year of your apprenticeship. The national living wage applies if you're aged over 21. Expenses are a payment to reimburse a worker or employee for costs that they've incurred. And mandatory training is any training that an employer says an employee or worker needs to do. In this webinar, we're going to look at the questions our helpline advisors tell us that they're asked about most frequently on the Acas helpline from employers and employees. So let's move on now to have a look at what those questions are. So first up, this is a very common one that we receive on the helpline about wages. So my employer hasn't paid me and I've got bills to pay. What can I do? So by law, an employer must pay a person's wages on the agreed pay day. An employee's first step would be to talk to their employer, payroll team, or manager. If the employee is in a union, they could talk to their trade union representative. They should then confirm what's being discussed in a letter or an email. This could resolve the issue quickly if there has been a mistake. If this does not resolve the matter, an employee can make a formal complaint to their employer, setting out how much they believe they're owed, along with any evidence, for example, pay slips, timesheets, or written agreements about pay or hours. If an employee has been unable to resolve the issue with the employer, they might be able to make a tribunal claim. For unpaid wages, the claim must be made within 3 months less a day from the day this should have been paid. If a person does want to make a tribunal claim, they must tell Acas first. And our next question is, when should I receive the national minimum wage increase? So the increase in national minimum wage is effective from the 1st of April. When a worker receives the increase will depend on how they're paid. If they're paid weekly, the pay reference period is a week, and for monthly paid workers, it's a month. The rate is not applied until the first full pay reference period after the increase. So for example, if a worker gets paid for weekly and is paid on the 15th of April, the increase will only apply to wages from the 16th of April. Increases to national minimum wage are also paid if an employee or worker turns 18 or 21, or if an apprentice turns 19 and has finished the first year of their current apprentice, or an apprentice who is already 19 finishes the first year of their current apprenticeship. The higher rate starts to apply from the next pay reference period after the increase. If someone believes their pay has not increased in line with the national minimum wage, they should discuss this with their employer at the earliest opportunity. If an employer has not been paying the correct minimum wage, they should try to resolve this problem as soon as possible. And moving on to our next question. I'm still owed expenses that my employer is refusing to pay. What can I do? So, expenses do not fall under the legal definition of wages for the purposes of employment tribunal claims. Ideally, an employer should raise the matter informally, and if it remains unresolved, the employee can raise a grievance, which is a formal complaint. Employees should follow their organisation's grievance procedure. If an organisation does not have its own grievance procedure, employees must follow the steps set out in the Acas Code of Practice on disciplinary and grievance procedures. If an employee has been unable to resolve the matter internally, they can make a breach of contract claim. Breach of contract is a standalone claim at an employment tribunal. It does not need to be accompanied by another claim. However, employees who are still employed cannot bring a breach of contract claim to employment tribunal. There is a limit of £25,000 to the damages that can be awarded for breach of contract claims at an employment tribunal, and an employee who is still employed can take a breach of contract claim through the civil courts. Payments paid by a worker in respect of expenditure in connection with their employment, for example for tools or uniform, which leaves the person with pay below national minimum wage during a pay reference period, could be a breach of national minimum wage regulations. Claims for this can either be made to employment tribunal or via a complaint to HMRC. So moving on now to question 4. My colleagues on national minimum wage have had an increase. Am I entitled to the same pay rise? So the national minimum wage and national living wage rates are set out in law. Any wages that are above these minimum rates are set by the employer. There's no automatic legal right to an increase. Any increases to the amount employees are paid are negotiated either by the individual or with their trade union. And moving on now to our next question. I spotted an overpayment and agreed a payment plan. My employer has made a deduction ignoring the plan. What can I do? So it is the employee's responsibility to check that their pay is correct. In genuine overpayment situations, an employer has the right to recover overpayments if there has been an overpayment, and an employee and employer should try to reach a mutual agreement about how this will be paid back, as in most circumstances, an employer does have the right to claim back the money if they have overpaid wages. The employer should be fair and flexible and consider the well-being and mental health of their employees, and should act quickly if a worker does raise concerns about any overpayments. It's good practice to agree a payment plan to repay the overpayment, as this can help the employee to manage their finances. And an employee should find out from their employer the reasons why they did not implement the payment plan. It could be a simple admin error. It's advisable to do this in writing, so for example in an email, both so the employee and employer have a written record. If this doesn't resolve the situation, the employee may choose to raise a formal grievance about their employer's failure to adhere to the agreement. So moving on now to question 6. The pay rise negotiations have finished and pay is being backdated. I left before it was agreed. Am I entitled to the rise for the time that I was there? So there's no statutory right to a pay rise that's backdated to a time when an employee was still employed. The former employee could contact the employer and ask whether the terms of the agreed pay rise apply to them. If the pay rise was negotiated by a union, then the employee could contact the union to find out if it would apply to them under the terms of a collective agreement. If the employer does receive a query about a pay rise from a former employee, They should check any relevant company policies, and a decision should be communicated clearly in writing to the employee. So moving on now to our next question. I'm leaving my job and my employer is deducting training fees. Can they do this? So for an employer to make deductions for training fees, there must be a contractual clause or prior written agreement allowing for the specific deductions to be made. The prior written agreement must have been obtained before the training. Getting consent for a deduction for training fees after it's been taken is unlawful. The training must have been provided in full, and the amount deducted must reflect the cost of the training. Apprentices should not have wages deducted for their apprenticeship training. If training is mandatory for the job, it's likely to reduce pay for the purposes of calculating whether the national minimum wage is being paid, even if there's a clawback clause in the contract allowing the employer to make the deductions. Moving on now to question 8. I'm not paid the same as others in the same role. Can the employer do this? So it is good practice for employers to pay people doing the same job the same rate of pay. Sometimes, though, it might be reasonable to pay different rates of pay. Examples include working in different locations. Many companies pay someone doing the same job in London more than someone in Edinburgh because the cost of living is higher. Differences in pay can also apply where individuals have different levels of skill and experience. Many jobs in the public sector have a pay range which goes up each year to a maximum for the grade. And finally, some employers may pay workers more for night shifts to enable them to recruit people to work unsociable hours. By law, employers must not pay an employee less because of disability, race, religion or belief, sexual orientation, or any other protected characteristic. Employers should also be aware that men and women in the same employment and performing equal work must get equal pay. Equal work is work that equal pay law classes as the same, similar, equivalent, or of equal value. After a 12-week qualifying period, an agency worker will be entitled to the same pay as a comparable direct employee, though there are several exclusions. And moving on now to our next question. Should my employer be paying me when I'm off because of an accident at work? So employers are not obliged to pay an employee's full salary if an employee is off work due to an accident at work. What an employee does get paid when they're off work will depend on the terms of their contract. Employees who are eligible for statutory sick pay must be paid it as a minimum, but an employee's contract may pay more. And our final question for today is, I've been asked to complete e-learning on my day off. Should I be paid for this? So, if the training is mandatory, it means that the employer requires the employees and workers to complete it. Whether employees get paid for this training depends on what their contract says. So employees should take a look at their contract and talk to their manager about it. For employees who started work for their employer after the 6th of April 2020, their written terms must set out the training that they must complete, including any training the employer does not pay for. If a worker earns the national minimum wage or close to it, then the employer should pay them for time spent on mandatory training. This is because the extra hours spent on completing the training count as working time, and it might bring the worker below the national minimum wage. So that brings us to the end of our questions, and I do hope that you found going through our top 10 questions and answers on wages and national minimum wage and living wage useful. I'd like to remind you that this is one in a series of 5 webinars, and you can find recordings of past webinars and a link to sign up on the Acas website. So Acas do run training in person and digitally to meet your needs. For example, a few of the courses that we're currently running are Deductions from Pay, Contracts of Employment, and Managing Discipline and Grievance. The benefit of all our training sessions is that you can interact with our advisor, collaborate with like-minded individuals, and ask questions to ensure you understand the context in relation to your own situations. You can also follow up with the individual trainer if further support is required. We can also run any of our training for individual workplaces, and in this case, the content can be fully tailored to you. For more information on prices and how to book, please visit our website, head to the training section, or call us on 0300 123 1150. We really hope to see you on one of our courses soon. Our webinars do run regularly, so please join us again.